So, Your Honor, first up is Joseé Chan, 24 CF 1477.
Yes, and I swore in our interpreter this morning.
If I could just briefly just tell her with the interpreter.
Of course.
Joseé Chan, 24 CF 1477. The state and I have discussed this case quite a bit. We've done depositions. She is discussing a potential disposition with the complainant and her family. So we've agreed if we could put it on docket day. We are very much hoping for a resolution then. I would say plea or continue because at this point neither of us would like to go to trial. We're kind of just haggling over a resolution.
Okay. So we will schedule 24 CF 1477, Mr. Joseé Chan, for docket day June 16th at 9 o'clock, plea or continue.
Thank you, Your Honor.
Thank you.
Right this way, sir.
Okay.
Mr. Demore is up there.
So, Your Honor, I believe the interpreter is on Zoom.
Yes, and let me bring her in. Good afternoon. I'm Judge Clark, and let me swear in our interpreter, Ms. Villarreal. If you'll raise your right hand, please. Do you swear or affirm that you will accurately interpret the proceedings in Brazilian Portuguese this morning, or this afternoon?
I do.
Thank you, ma'am.
I do.
If you'll just state your name for us, please.
Belkis Villarreal.
Thank you very much. I'm Judge Clark, and we are here on case 25 CF 590.
Eu sou a juíza Clark e estamos aqui na causa 2025 CF 590.
Okay.
Your Honor, this is the first pretrial conference date up, and I have asked my assistant to start scheduling depositions in this case, so I would request a full cycle continuance.
Então, senhora juíza, esta é a primeira reunião pré-julgamento e eu estou a pedir à minha assistente que para ela começar a agendar os depoimentos. Então, eu quero pedir, senhora juíza, adiamento desta causa.
Any objection from the state?
Os promotores têm alguma objeção?
Who's the last?
Demora Martins. It's yours.
Right. No objection.
Não temos objeção.
Okay, the case will be continued at the defense's request.
Então, vamos adiar essa causa a pedido da defesa
To August 13th at 9 o'clock.
será adiado para 13 de agosto às 9 da manhã.
Thank you. And could I have the interpreter just let him know, could you let him know that I'm going to come see him at the jail next week, and I will be using an interpreter on language line.
A sua defensora pública está explicando que ela vai ir para a cadeia para ver o senhor a próxima semana e ela vai utilizar serviço de intérpretes.
Okay, tudo bem.
Okay, that's fine.
All right, thank you so much. And thank you to Madam Interpreter.
You're welcome. Thank you.
Your Honor. 24 CF 322. The state and the defense have reached an agreement. I just need to have Mr. Clayborn sign it.
Oh, great, thank you.
And I also have a score sheet.
Great.
Oh, this is not. Your Honor, I think we'll have to provide the score sheet in a few minutes if we could.
Sure. Thank you. Thank you so much.
I'll have the score sheet ready after the colloquy.
Great, thank you. Sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down. If you'll just state your name for me, please.
Toron Clayborn.
Thank you. You're here in case 24 CF 322, and the charges in that case are possession of a weapon by a convicted felon, that is a second-degree felony, possession of cocaine, that's a third-degree felony, resisting an officer without violence, that's a first-degree misdemeanor, and driving while license suspended, first offense, that's a second-degree misdemeanor. Have you had a chance to talk to your lawyer about all of those charges and any possible defenses?
Yes, ma'am.
All right. Did you discuss the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes.
Is that your signature on the last page?
Yes, ma'am.
Do you understand the rights that you give up when you enter a plea?
Yes.
Are you entering the plea freely and voluntarily?
Yes.
Is anybody forcing you or threatening you to make you enter the plea?
No, ma'am.
Has anybody promised you anything other than what's showing in your agreement?
No, ma'am.
Are you happy with the services of your lawyer?
Yes.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, ma'am.
All right, and I'll go over the score sheet in just a minute. Is there any DNA?
Not that I'm aware of, Your Honor.
All right, I do find a sufficient factual basis based on my review of the arrest report. And sir, do you understand if you're not a U.S. citizen, the plea will subject you to deportation?
Yes, ma'am.
All right. And it looks like you're pleading to a lesser included offense on count 1 of improper display of a weapon, which is Florida Statute 790.10. Is that your understanding too?
Yes.
All right, and that is a first-degree misdemeanor, it appears, correct?
Yes, Your Honor.
Okay. All right, sir. Well, let me just check on the score sheet.
Sorry, Your Honor.
This is not going to, is it going to be a downward departure, or is it?
No,
Okay.
Your Honor, it's not.
All right, good. Sir, how do you plead to the lesser included offense that I just mentioned of improper display of a weapon as to count 1, and then counts 2, 3, and 4 will be as charged?
Yes, ma'am.
No contest.
How do you plead?
No contest.
I accept your plea. I find it was freely and voluntarily entered in accordance with your agreement. There will be an adjudication of guilt on all counts. As to count 1, on that lesser included offense, you are sentenced to 11 months and 29 days in the Okaloosa County Jail with credit for time served. This will be concurrent on all counts. or all counts will run concurrently with each other. And on count 2, adjudication of guilt, 11 months, 29 days in the Okaloosa County Jail with credit for time served, again, concurrent. Count 3, adjudication of guilt, 11 months, 29 days in the county jail with credit for time served. Count 4, adjudication of guilt, and the sentence on that count is just simply time served. And the court costs are $515 in court costs, $150 public defender fee. That includes the $50 application fee. You will have 24 months to pay your fees and costs after you get out of jail before they go to collections. And is that the score sheet? Oh, great.
Just making sure he knew what it said.
Thank you. Any objections or corrections? I fixed it. It's no problem. So the score sheet that I received shows 27.1 total sentence points. And, sir, you have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, I'll appoint one for you. Good luck to you. Thank you.
Your Honor, this is Preston Davis, 25 CF 522, 25 CF 524, and 23 CF 199. Excuse me, the state attorney and I have been discussing this case at great length. I believe that we are close to a resolution. We would both like to put it on docket day. I think that we will be able to work it out by then.
That's without objection, ma'am, and I will get you the updated score sheet so we're all on the same page for Monday.
Perfect.
Wonderful. Okay, I will set all 3 cases for June 16th, docket day at 9 o'clock for a hopeful resolution.
Monday. It's Monday. Yeah, 16th is Monday. Yeah. Okay.
Thank you.
Okay.
You want one, this is next.
No, wait, he was that first.
Vince Davis is next.
Your Honor, next up is Vince Dennis, 23 CF 1879.
All right.
Mr. Dennis would like to set this case for trial.
Okay. And is the state ready?
So this is the first time up, but the state will oblige Mr. Dennis if he wants a trial. We have not spoken with the victim. The victim was wavered on her opinion on how things are to move forward. I think if we set this for Monday, clear trial, it's going to either be set for trial or a different resolution.
Okay, so I will set the case for June 16th, that's docket day. Good morning, sir, good afternoon, sir, I'm Judge Clark, I don't think we've seen each other before. Docket day, June 16th at 9 o'clock, plea or trial, and when the state is discussing the case or reaching out to the victim or whatever you need to do and your witnesses, hopefully we can set this case on the first week, because the second week that we have this cycle is getting jam-packed. So hopefully, let's aim for the first week if we have to go.
Yes, Your Honor.
Okay, thank you. So I'll see everybody on June 16th, that's Monday, plea or trial, 9 o'clock. All right, thank you.
Thank you. Your Honor, this is Isaac Dumis, 24 CF 2381, 24 CF 2369, and 25 CF 328. The state and the defense had a global resolution worked out. However, Mr. Dumis picked up a case at the jail. However, we're going to be able to wrap that case in with these 3 as part of a global resolution. It just is going to take a couple weeks for all the paperwork to get it transferred. I think yesterday they filed it to get it transferred down here. We tried to do it in time for today, but that was not going to happen. we have to, Mr. Sprouse has to do the intake on it and everything. So I'm hoping that we could maybe put it on a miscellaneous date in July, if possible, just because we have everything worked out. We just need to get the Crestview case transferred here. That's it.
Would it help if I made an oral order to transfer it today? Would that help speed things up?
I don't think so, Your Honor. I think
Okay.
that we still have to go through some of the steps with the state attorney's office, and then I don't have the file yet officially.
Okay.
So unfortunately, I think we just need to give it a couple weeks.
That's fine.
Correct. And the only reason I was made aware is because the warrant was served and I got an email about it yesterday.
Okay, so I could do a couple of different things. I could go ahead and set everything for August 13th, and then y'all can bring it in whenever you have everything worked out. I will find time to do it.
Let's do that, because then if we get even earlier than mid-July, then that's great.
I mean, if you can, if y'all get it worked out, we will find time. We can
Yes.
find time. You tell me when, and I'll make time. So, sir, I'm setting this for August, but it is with the understanding that your lawyers, once your other case gets transferred to them, they're going to get together, and they're intending to bring you in a lot sooner than that to resolve everything, assuming everything's good with you. But, so don't be, disturbed by the August date. The plan
Thank you.
is quite a bit sooner, and I'll do what I need to do to get it in early. So August 13th at 9 o'clock on all cases. That's 25 CF 328, 24 CF 2369, and 24 CF 2381, with the understanding there is a new case coming. And y'all let me know when you need to bring it in, and we'll do that.
We will. Thank
Okay.
you.
Henry Ericson is next. Right, Spencer?
This is Henry Ericson, 24 CF 1607. Similarly, Mr. Ericson has a case, a Crestview case that I believe is being transferred down here to run the two together. So if for now we could put this one on the August date, and if we're able to work something out, similarly, once that case gets transferred, then we will schedule an early plea.
So I actually have two new cases noted. I have 25 CF 1145 and 25 CF 1151. So I guess both of those will be, if they're not already assigned to me, they'll be coming.
Yes, I think that
I'll
would
look
be.
at both of those, ma'am, and if they are both of the same or similar nature, I'll get those all brought down here.
Okay, so when we were in court in April 14th, of course, the new
I know
cases.
that we noted last continuance, that was because we were hoping to resolve them. Now, I mean, we're still hoping to resolve all three together now,
Okay.
because they are similar, at least if I recall correctly, they're similar charges, so we should be able to do everything together by the August date.
Okay. State, what's your position? I know that,
State has no objection, ma'am, and they are all basically of a failure to register nature, so it would be appropriate for us to go ahead and handle those all together. So there's no objection to continuance, just have them all travel together.
okay, prior to the new charges occurring, or allegedly occurring, was there some progress to a resolution? And do we
Yes,
think
Your Honor,
that?
there is a witness who it's a state's witness who I'm trying to get in contact with, who I think would be helpful to resolve the case. We also, Ms. Basso and I have been speaking about this case quite often. I do have an offer, but
Okay,
especially now that there's the two new cases that are essentially the same charges, it just would make sense to continue once more so that we can hopefully wrap them up together.
in light of the new charges, I will go ahead and continue this older case, 24 CF 1607, which, I mean, it's coming up on, next month will be a year old, but I understand that just last week is when
Yes.
the new cases came into existence. So all cases will probably end up being set on August 13th. I don't think these two new ones, I don't know if they're assigned to me or not, but
The two new ones, ma'am, appear to be with Judge Oberleeson.
Okay.
And they're Glenn and Maddox, pretrial, the public defender's office, and Ariana Leon are with us, but they'll be moving to me and Ms. Vargas.
okay, so they'll be coming. So eventually, everything will be set on August 13th, I would think. But for now, I can only deal with 24 CF 1607. We will set it August 13th for pretrial, with the expectation the other two will come and track along with it too.
Thank you. And I would just like to note for the record, because it's kind of rare sometimes, Mr. Erickson's brother and sister-in-law were in court all day Monday because they thought that he was on the docket Monday, and they were here all morning today. So I just always like to note when clients have family here.
Sounds like you have a good support system,
Yes, Your
sir. Yeah,
Ma'am,
yeah.
I also have some people that are relying on me to help out. I have a friend that's a paraplegic that I do take to school, to the banks, to the store, to do grocery shopping, to the bank whenever I needed the mail. I understand my bond was revoked. I'm not sure why it was revoked, but if you've seen, and you can ask my attorney here, ma'am, I was here every day for court. Whenever y'all had set a court date, I was here until she said it was going to be waived. Is there any way I can have that bond not reinstated or granted concurrent with a $1,000 bond?
You need to discuss that with your lawyer, sir. It looks like your bond was revoked at first appearance on June 5th when you picked up the new charges. So the first appearance judge revoked your bond. But that's something you need to talk about with Ms. Farkas, okay?
Thank you, Your
ma'am.
Honor.
Thank you. I'll see you in August, if not before.
Vernon Eland is next.
Your Honor, Vernon Eland, 24 CF 1473 and 24 CF 2844. I received an updated offer from the state attorney today after much negotiation between the two of us. There is an issue with the docket 2844 that both of us need to do some research on as to, the statute is very fiddly. So if we could have, I know that the 1473 case is quite old at this point, but if we could have a full cycle continuance, because it is a DOC offer for both cases.
Okay, so on 24 CF 1473, I have that one down as last continuance on April 16th. Is the state ready on that case?
We could be, ma'am. We were, like I said, we were trying to negotiate both of the cases together. But then Ms. Farkas pointed out that there might be a concern, so I wanted to do some additional research as well.
Okay. How long do you think it will take to do that? I know you're in court a lot, almost every day.
To do the research?
Yes, like I'm trying to figure out if we can get 24 CF 1473 tried if necessary this cycle.
I think we should be able to find an answer
Yes.
on whether or not the second case is valid, based on the concerns Ms. Farkas raised. Within, I would say, no more than a week, but we'll try for certainly sooner than that. I was actually starting to look at it right now. But,
Okay, well, so as to 24 CF 1473, I know there's this issue that's going to be researched and that might impact a global resolution of
Yes.
both cases and all. But setting that aside, could both parties be ready, or are both parties ready on 24 CF 1473, assuming there is no resolution of both?
I suppose that we could be. I would just say that I don't know that either party wishes to go to trial. I know that the case is old, but this is another one where we are working towards a resolution as opposed to preparing for trial. Just
Okay.
the circumstances of the cases are such that that's not an outcome that the defense is seeking, nor do I believe the state is seeking. We're instead hoping that we can resolve it without having to take up trial time.
I would say it's well.
Okay, what I could do is set the case on June 19th for jury review on that day or in the afternoon for a resolution if, I mean, but that's, you know, I know that Miss, also you're gonna be probably in court with me on some tomorrow, I'm not sure, and then probably Monday and probably Tuesday. I mean, I know you're gonna be.
Accurate.
Yeah, so what I'm trying to do is keep things on track. This case is, this one case is a year old, so,
I understand that it's a year old, but it's 4 third-degree felonies. So I don't mean to say that, like, it should resolve easily.
mhm.
It's a serious enough case that sometimes it just takes a little bit of time.
Okay.
It's unfortunately the way it goes sometimes.
Okay, so in light of that, what I'll do is August 13th on both cases. Please bring this case in early if there's a resolution, so we can just get it off,
That is
get
the
both
hope.
of them off the docket.
Ma'am, what I'm gonna try to do is get with Ms. Farkas prior to the 19th. And we'll leave it set out there in August, but if we can get it resolved, then we can always slide it back in next week.
That's
Does that
all
sound
right.
good?
Yes, or even the week after, or whenever, if you
Yeah.
reach a
We'll shoot for that,
resolution,
ma'am.
please.
Always
I would-
happy to do it as well.
Yeah.
I am
It's
always
going on right
happy.
now, so.
I'm always happy to take an early plea. It will help shrink our docket more. So let me know and we'll get it in. August 13th, we need to resolve it no later than next cycle.
All right, sir. Next up is Gavin.
No problem. Gavin Flechman, 25 CF 640. Your Honor, excuse me, this is Gavin Flechman. This is the first pretrial conference date up, and my office is starting to set depositions. There are only a couple witnesses, and then I think maybe one law enforcement, so we should be able to get them all done in a pretty
Without objection.
short order.
All right. So case 25 CF 640 will be continued at the defense's request to August 13th, 9 o'clock for pretrial.
All right, Judge. Next up is Preston Ramos.
All right. That's 25 CF 634.
Right this way, sir.
Right, exactly.
Yes, continued, questions continued at the defense's request to August 13th.
Your Honor, this is Pedro Fetta Ramos.
Okay.
We need the assistance of the Spanish interpreter.
All right, and I swore her in earlier today.
Yes. The state and the defense have reached an agreement. If I may approach, Your Honor?
Yes.
This was actually signed, I want to make sure I give you the signed copy. Yes.
Thank you.
It was signed last month. Sorry.
No problem. Thank you.
And it's a plea to misdemeanor charges, so there is no score sheet necessary.
All right. All right, sir, if you will raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
Yes.
Thank you. You can put your hand down. I'm Judge Clark. Could you please tell me your name?
Pedro Pastor Fresneda Ramos.
Thank you, sir. You are charged in case 25 CF 634 with one count of tampering with evidence. That is a third-degree felony. One count of possession of drug paraphernalia. That's a first-degree misdemeanor. And one count of driving without a valid driver's license, which is a second-degree misdemeanor. Have you had a chance to talk to your lawyer, Ms. Farkas, about those charges and any possible defenses?
Yes, I have.
Sir, do you read or write English?
No.
I see that the plea agreement is in English. Did someone read it to you?
Your Honor, I went over it with him last month, actually. We had come in for a court date in May, and I went through the plea agreement with him then, so I didn't do it today. If you would like that, I'm happy to do it again.
Sir, has someone read and discussed the plea agreement with you?
Yes.
Okay. Did Ms. Farkas read and discuss the agreement with you? Thank you, sir. Did you sign the agreement?
I can show him.
Yes, thank you. Right there.
Yeah, yeah.
Yes, it, yeah.
I was just reminding you that we signed it last month.
It does have a date of May 15th, 2025. Do you remember signing this agreement on that day? Okay, is that a yes?
See, yes.
Okay, yes, thank you. Thank you. Do you understand the rights that you give up when you enter a plea? I will go over those with you to make sure. Sir, do you understand that by entering the plea, you are giving up your right to plead not guilty and to have a trial? Do you understand you have the right to have a trial?
Yes, but it's not necessary.
Okay. Do you understand that you're giving up your right to have a trial by entering this plea agreement? Is that a yes?
Okay.
Do you understand that you are giving up your right to have an attorney represent you at trial?
See,
Yes.
Do you understand you're giving up your right to remain silent and not incriminate yourself?
yes,
Do you understand you are giving up the right to have the state prove that you are guilty beyond a reasonable doubt?
okay.
Do you understand you're giving up your right to confront witnesses against you and cross-examine those witnesses?
Yes,
Do you understand you're giving up your right to defend yourself by calling witnesses and presenting evidence?
okay, yes,
Are you entering the plea freely and voluntarily?
okay, yes,
Is anyone forcing you or threatening you to make you enter a plea?
no,
Has anyone promised you anything other than what is in your agreement?
no,
Are you satisfied with the services of your lawyer?
yes,
Did she answer all of your questions?
okay, see,
Do you need any more time to talk to your lawyer before we move forward?
no,
Do you have any questions about anything that I have asked you so far?
no, no,
Is there anything that I have said that you did not understand?
No, everything is understood.
Wonderful, thank you. Please let me know if I say anything that you don't understand, okay?
No, everything is clear.
Thank you. Have you had any drugs, alcohol, medicine, or any type of substance in the last 24 hours?
No.
This question is to Ms. Farkas and to the state. Is there any DNA evidence?
Not that I'm aware of, Your Honor.
No, Your Honor.
Thank you. I do find a sufficient factual basis based on my review of the arrest report. Sir, do you understand that if you are not a U.S. citizen, the plea could subject you to deportation?
I was just repeating the question.
Okay, yes, I'm not asking if the defendant is a citizen. I am asking if he is aware that if he is not a citizen, the plea could subject him to deportation.
Yeah, I understand.
It looks like you are entering a plea to count 2, possession of paraphernalia, and count 3, driving without a valid driver's license. How do you plead to those 2 charges?
No contest?
I accept your plea on counts 2 and 3, and I find it was freely and voluntarily entered. Does the state have an announcement on count 1?
Noel Pross for plea to the other charges.
Thank you. In accordance with your agreement, on counts 2 and 3, there will be an adjudication of guilt on each of those charges, and you are sentenced on each charge to credit for time served. Is it $300? Okay. And there will be $300 in court costs, $150 public defender fee. That includes the $50 application fee. You will have 24 months after you get out of jail to pay those costs before they go to collections. You have 30 days to appeal the order of the court. If you cannot afford a lawyer, I will appoint one for you. Good luck to you, sir.
Sorry. Thank you.
All right.
Thank you, Your Honor.
Thank you.
Ferguson is next.
Okay. That is 23 CF 445 and 24 CF 1069. And the defendant is present.
Your Honor, the state and the defense have reached an agreement in this case. I'm just going to have my client sign it.
Thank you.
This is the last page of the plea agreement. And I'm also providing my client with a copy of the plea agreement.
Thank you.
I get all the time without it being here, right?
And she'll announce it on record.
What time is it?
It says it right there. This is your copy. All right. If I may approach?
Yes, thank you. Thank you so much. All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. And could you tell me your name?
Ferguson Jr.
Thank you. You're here in case 23 CF 445 and 24 CF 1069. In 23 CF 445, it's alleged that you violated your probation. And in case 24 CF 1069, it looks like you're charged with one count of possession of marijuana greater than 20 grams. That should be a third-degree felony on here. And, well, actually, according to my docket, it is possession of marijuana.
I'm sorry, it was charged, I am bad at math, it's the under 20 grams.
Okay, no
I
problem.
wrote greater than.
No problem,
That's
it
why I'm
was.
a lawyer.
I get it now, thank you. It should be a misdemeanor.
Yes.
It's under 20 grams. So count one is possession of marijuana less than 20 grams, or not more than 20 grams, which is a first-degree misdemeanor. And count two is fleeing and eluding law enforcement with lights and sirens activated with disregard for the safety of persons, which is a second-degree felony. Have you had a chance to talk to your lawyer about the allegations you violated your probation in case 23 CF 445 and the two new charges in 24 CF 1069?
Yes, ma'am.
Did you discuss the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is this your signature on the last page?
Yes, ma'am.
All right. Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
Do you understand you're giving up your right to have a trial in 24 CF 1069?
Yes, ma'am.
Do you understand you're giving up your right to have a contested hearing on the issue or the allegations that you violated your probation in 23 CF 445?
Yes, ma'am. Yes, ma'am.
Do you need me to go over that anymore?
No, it's okay. I'll just make it. It's all right. You continue on.
Okay, do you need any more time? I mean that sincerely. If you need more time to look at anything,
I just want to like.
take your time.
I want to understand this, all right?
Absolutely, I want you to understand it too. Take your time.
We're just making sure that everything says concurrent, coterminous, and then making sure we understand what that means. This is very
Absolutely,
confusing.
absolutely. So, sir, I will give you all the time you need to talk to your lawyer. I mean that with all sincerity.
Yes,
You
ma'am.
tell me if you need more time, okay?
Yes, ma'am. No, it's okay. I just wanted to make sure I understood the terms of coterminous and concurrent.
Yes, and it can be confusing, I understand
Yes,
that.
yes, ma'am.
I get it wrong a lot.
That coterminous word is kind of like long and like weird.
You know, it's a word that I've never heard except in these types of cases.
Yes, ma'am.
So it's not something somebody would come across every day.
Yes, ma'am.
All right, sir. Do you understand you have the right to have a trial in 24 CF 1069 and you're giving up that right?
Yes, ma'am.
Do you understand you have the right to have a contested hearing on the allegations that you violated your probation in case 23 CF 445 and you're giving up your right to have that hearing?
Yes, ma'am.
Is anybody forcing you or threatening you to make you enter the plea?
No, ma'am.
Has anybody promised you anything other than what's showing in your agreement?
No, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Are you satisfied with the services of your lawyer?
I'm definitely satisfied.
That's good
Yes,
to
ma'am.
hear. Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, ma'am.
I do have a score sheet. It shows 64.8 total sentence points. The lowest permissible sentence is 27.6 months in state prison. Are there any objections or corrections to the score sheet?
No, Your Honor.
Is there any DNA in the new case?
Not that I'm aware of.
And I do find a sufficient factual basis based on my review of the arrest report. Sir, in case 23 CF 445, are you admitting to the allegations that you violated your probation?
Yes, ma'am.
All right, and I accept your admission. I find it was freely and voluntarily given. In 24 CF 1069, how do you plead to counts 1 and 2?
No contest.
I accept your plea. I find it was freely and voluntarily entered. And in case 23 CF 445, probation will be revoked and terminated. And you will be sentenced on each count to 27.6 months in the Department of Corrections State Prison with credit for all time served. And the counts will run concurrent and coterminous, meaning they run together and they end at the same time. And that will be the same once I get to count 2 of 24 CF 1069. All of the counts that you're going to prison on will be concurrent and coterminous, meaning running together and ending at the same time.
Yes, ma'am.
So going back to 23 CF 445, you will also have a $150 cost of defense fee. That includes the application fee and a $100 cost of prosecution fee. You will have 24 months to pay all of your outstanding financial obligations after you get out. Then it will go to a lien. So that'll affect your driver's license. So make arrangements to take care of it after you get out, okay?
You said it affects my driver's license?
If you don't pay within 24 months after you get out of prison, this will suspend your license,
Yes,
the
ma'am.
unpaid fines and
Yes, ma'am.
costs.
Yes, ma'am.
So you got 2 years, 24 months after you get out to pay all your fines and court costs.
Yes,
And
ma'am.
then, if there's anything unpaid, that'll go against your license.
Yes,
Okay,
ma'am.
all right. And then in case 24 CF 1069, as to count 1, that's a misdemeanor, there will be an adjudication of guilt and you're sentenced to credit for time served. Count 2, that's second-degree felony, there is an adjudication of guilt and you're sentenced to 27.6 months in the Department of Corrections State Prison. Again, this will be concurrent and coterminous with the other case. So all counts, all cases are running concurrent and coterminous.
Yes, ma'am.
You will get credit for all time served. And in that case, is it 515? Correct. 548. Okay, I have to change the court costs on here. It's actually $548.
Thank you.
548 instead of 515. Then there is a $100 cost of defense fee. You will have 24 months after you get out of prison to pay those fines and court costs and fees before they go to collections. Once they go to collections, then that's when it affects your license. So you have time to make arrangements to pay those. Did I cover all the terms and conditions?
Yes, Your Honor.
Okay. Sir, you have 30 days to appeal the judgment and sentence of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you, sir.
Yes, ma'am.
Thank you.
Bless you.
Thank you.
Thank you all.
Thank you, sir.
I was just telling him his sister was here all morning, and so she wanted to say hi, but she had to leave.
Thank you, sir.
Your Honor, I have a few more, but they are waivers, so I think Mr. Hayes.
Okay.
That's not mine.
Yeah, it's mine.
I don't want silver in my name. It's not my name.
First up is going to be Matthew Jones before the court. He's before the court in 21 CF 1620 and 24 CF 1327. We have a plea agreement to be filed in this case, if I may approach.
Yes. Thank you. Great, thank you so much. All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
Yes.
Thank you. You'll put your hand down. If you'll just tell me your name, please.
Matthew Horace Jones.
Thank you. In case 21 CF 1620, it is alleged that you have violated your probation. And in case 24 CF 1327, you are charged with one count of vehicle theft, which is a third-degree felony, and one count of false ID given to law enforcement, which is a first-degree misdemeanor. Have you had a chance to talk to your lawyer about the allegations that you violated your probation in 21 CF 1620 and those new charges in 24 CF 1327? Wonderful. Thank you, sir. Did you read and sign the plea agreement?
Yes, Your Honor.
All right. And did you discuss the plea agreement with your lawyer?
I did.
Is that your signature on the last page?
Yes, Your Honor.
Thank you. Do you understand the rights that you give up when you enter a plea?
I do.
Are you entering the plea freely and voluntarily?
I am.
Is anyone forcing you or threatening you to make you enter the plea?
No, Your Honor.
Has anybody promised you anything other than what is showing in your agreement?
No, Your Honor.
Are you satisfied with the services of your lawyer?
I am.
Did he answer all of your questions?
Yes, Your Honor.
All right. Have you had any drugs, alcohol, or any intoxicating substance in the last 24 hours?
Only that I've been prescribed.
All right. Does that medication affect your ability to understand what you're doing right now?
No, Your Honor.
Okay. I do have a score sheet. It shows 54.9 total sentence points. You said no objection, right?
Yes, Your Honor.
Okay. Is there any DNA in the new case?
No, Your Honor.
All right. I do find a sufficient factual basis based on my review of the documents in the court file. And it appears that this is a downward departure, correct?
Yes, Your Honor.
Okay. And to the state, is this a legitimate, uncoerced plea bargain?
Yes, it is, Your Honor.
Thank you.
And Your Honor, just a clarification on that. part of that is because Mr. Jones had been in Florida State Hospital for an extended period of time.
Yes.
So that ate up a lot of his incarcerated sentence.
Yes, and I have a note of that. Welcome back. Hopefully said that to you when I saw you in April, but
I believe you did.
welcome back. It's good to see you feeling a lot better. Mhm.
Yes, Your Honor.
Yes. Sir, do you understand if you're not a U.S. citizen, the plea could subject you to deportation?
I do.
All right, thank you. Are you admitting the allegations that you violated your probation in case 21 CF 1620?
I am.
I accept your admission. I find it was freely and voluntarily entered. And in case 24 CF 1327, how do you plead to counts 1 and 2?
No contest.
I accept your plea. I find it was freely and voluntarily entered. In accordance with your agreement, in 21 CF 1620, probation is revoked and terminated. It appears there's a previous adjudication of guilt, but in case there wasn't, there is now on both of those charges. And you are sentenced to credit for time served, and the court is imposing the mandatory $100 cost of prosecution fee and $150 cost of defense fee. That includes the $50 application fee. In case 24 CF 1327, on both counts, there will be an adjudication of guilt and a sentence of credit for time served on each count. Is it $515 in court costs, $100 cost of defense fee, and on both cases you will have 24 months after you get out of incarceration to pay your outstanding court costs and fines and fees before they go to collections. So you can go see the clerk, they'll get on a payment plan with you, and you can do that, or you can, you have 2 years to pay them. But once they go to collections, if you don't pay within that time, it will affect your driver's license, okay? All right. And did I leave out anything, Mr. Gates?
No.
Okay. And sir, you have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, I will appoint one for you. Good luck to you, sir. Thank you.
Eric.
It was Mr. Ghound before the court in 24 CF 1393 and 24 CF 2758. This time, the defense is going to ask for continuance. Your Honor, we've been steadily working through the depositions in Mr. Ghound's cases. I think we've had 3 rounds of depositions. We're going to need additional rounds. I know there was conversation about setting it for trial this cycle. Unfortunately, we got service on a couple officers who didn't show. And then we also have an issue with an officer who is the primary witness to 2 of the charges, the fleeing, eluding, and carjacking, who is on long-term military deployment. So I need to figure out how to address the potential issue with any evidence or testimony the state might present for that officer. So I've asked the court to let me continue Mr. Ghound's cases. With all that said, I won't be adequately prepared for trial for this cycle without getting that information.
Do you happen to know which officers didn't show up? I know that Judge Stone was going to look into, the...
Yes, Your Honor. It was, the ones we served, it was Timmy Lee, the officer, Deputy Lee is no longer with the Sheriff's Office, so I've got to get an updated address for that. And then Deputy Padilla as well. And then I was looking at discovery in preparation of having to make an argument for continuance. The state still has Officer William Helton for Beach listed in discovery as Fort Walton Beach, but he no longer works there. He actually works at Northwest Florida State College, so they may want to update discovery on that end. I haven't sent him the subpoena yet. He will be on my round to get done before next court day.
Thank you very much. So Deputy Padilla was served, but, okay.
Yeah, I will go on record, Your Honor. I've known Deputy Padilla for a while, and it's unusual for him. Typically, if there's an issue, they'll let me know. So I have a suspicion he probably got caught up on a call or something and just couldn't make it. I don't typically press first time out. Usually it's after the second one I get service. That's when I'll follow the appropriate motion to compel with the court.
That is fine. We're just trying to make sure that, because service usually occurs on someone else.
Yes, ma'am.
And we're trying to make sure that the communication pathways are working.
Yes, ma'am. And I think, speaking from experience, I know law enforcement typically serve by proxy on someone at their department. They either send an email and then place the hard copy of the subpoena in their box. Sometimes they don't get those emails. I've done it long enough, as I said, Your Honor. Typically, my issue is if I get 2 services on you don't show, that's when I know, at least for me, I'll do a motion to compel, have the hearing, and then try to schedule that third deposition.
Yeah, that's great. It just seems like every time in every case, when there's a bunch of depositions set, there's, I'm trying to remember if I'm aware of one where everybody showed up.
I've had a few that I have, Your Honor, and
Okay.
the other issue is that the state's listed one witness as married with nothing else, no identifying other than just married, so that makes it kind of hard to serve that witness as well.
Okay.
I know that we're trying to get this trial. Mr. Ghound wants a resolution. There are 3 charges on here that are 10-20 life. I'm just trying to make sure I cover my bases and do what I need to represent him
I understand.
appropriately.
I understand. What is the state's position?
The state's position is that we're ready for trial
In both cases?
in the, in 1393, I believe.
Okay.
That's the one that we would be moving forward on. And I was told that there's possibly a motion for severing some of those counts because there's a lot of counts in that particular case. As far as the deputy that's on extended military leave, there's no telling when, I don't know when that's going to end, and it would be illegal for us to compel his appearance. So we're still working towards a resolution. Unfortunately, it doesn't appear that we're going to get to trial anytime soon.
And I'll respond to that. I highly object to that phrase. I think we will get to trial, Your Honor, as soon as I can get prepared. As I said, with him on long-term military leave, there are certain aspects that I've got to be able to research to determine if the state can even provide any testimony from that officer. That officer's got body-worn camera, that officer's got in-car video, that officer took written statements from witnesses. If he's unavailable due to military, does that mean the state gets to have that brought in as evidence? Do I need to file a motion to exclude to have it stricken from the record? Can the state prove the charges if the court creates a motion to exclude that testimony? Those are all things I need time to be able to research that I won't be able to do before court, which is why I said I wouldn't be adequately prepared for trial for the cycle.
Understood. So the officer that's on long-term military duty, is that officer involved in 24 CF 1393? Okay.
Yes, Your Honor. He is specifically the officer involved in the carjacking, 10-20 life, and the fleeing attempting to elude charge.
Gotcha. Okay. Question about the other case, 24 CF 2758. Is that something that, setting aside the case with the 10-20 life charges, the case 24 CF 2758, that's all third-degree felonies in that case. Is that something that could be geared up to go?
Your Honor, my
sometime
purpose
soon?
would be on that would be to let me make sure we got all the deadlines on that, and then set that for trial next October if we need to.
Okay.
And all candor with court, the conversation with Mr. Gahan is, it comes down to, he understands that some of these charges we're probably going to either enter a plea, whether that be with the state or the court. There are really 2 charges on the information that we have the most issue with.
Mhm.
That seems to be the sticking point.
Right.
We've tried to negotiate a plea agreement that would be add guidelines for what we think is appropriate charges. The state position is a sentence that is an upward departure from what the guidelines would be. So that's a bit hard for Mr. Gahan to agree to.
Okay.
So I'm trying to make sure I do what I need to make sure we get this either trial or not.
Okay,
And that's how I approach all cases, and I've had the conversation with the state before. My position is always, I try to negotiate the case, but at the same time, I prepare for trial, because those are the only two conclusions we can come up with. Is either plea or trial. I don't waste a lot of time. I don't try to kick a case on the road. I think the court has seen, if I say I'm going to do something between now and the next court date, I do that. I don't come in and say I haven't done it.
thank you, Mr. Gates.
Yes, Your Honor.
So, anything further from the state?
No, Your Honor.
All right, I will then grant the continuance, August 13th at 9 o'clock in both cases. Hopefully, something can be found out about the one officer who's on military duty. Maybe he'll come back.
Excuse me, that was
soon, or-
going to be my suggestion. Maybe the state can reach out to Long Beach and see if they can give an idea on when he might be returning. That would give us an idea on that. Also, is it necessary for me to file a motion separate, or is the state going to kind of agree that some of these charges should be tried separately?
The state would not stipulate to that because it's all one continuing event. But of course, defense will have arguments and state will have arguments.
And I just want to make sure you're on that. I know on there's one particular charge, I'm sure the court can see that absolutely would have to be severed, so I don't see why the state would agree to release that charge.
I do see.
But if the state would prefer, I will be glad to file a motion to sever and try to get that scheduled closer to next pretrial conference.
That's the possession of a weapon or ammo by convicted felon.
Yes, Your Honor, that one clearly would need to be severed from any other trial that we have.
Understood.
And the state would stipulate to that charge being severed.
Okay,
That charge comes with a minimum mandatory of 3 years.
okay. Just write that down.
Then, as I said, I will look at filing appropriate motion to sever on some of the other charges
Okay.
as well, given some of the implications for the officers that may be prudent as well.
Okay. Well, thank you for that very comprehensive update. I do appreciate it. It helps me keep track of things and know where we stand, so thank you.
Yes, sir.
All right.
This is going to be Mr. Gilday before the court in 25 CF 436. This is the first pretrial with me. We have gone through discovery at the jail. I let him kind of review it. We got video surveillance and body camera yesterday, actually early this week. I reviewed it yesterday. I will tell the court in all candor my expectation based upon what I saw is to do depots and then immediately file a stand your ground motion. I think based upon the video surveillance from the store, Mr. Gilday did nothing but act in self-defense. Given that, I'd like to do the depots at the very least on the two victims listed in the case and then prepare for a stand your ground hearing.
All right. So you're requesting the August 13th date?
Yes, Your Honor.
Any objection from the state?
No objection to the state, Your
All
Honor.
right. Then 25 CF 436 will be continued at the defense's request to August 13th at 9 o'clock. Thank you.
Davion Graham.
This is coming Mr. Graham before the court. We had a round of depositions. We got service on everybody but the victim. Unfortunately, it looks like the victim is in the wind. I've asked the state to take a look at that. I think we had an agreement that the state would send out their drop dead letter. In the meantime, I would continue Mr. Graham's case, schedule depositions, and if we didn't get a response in an appropriate amount of time, we would bring him in sooner for a resolution.
All right. What's the state's?
That's the plan. We are trying to locate the victim in this case. We have exhausted our means of locating the victim, and as far as a 10-day drop letter, it will go out, but it will be returned. But that is the plan.
Okay, so Are you requesting the August 13th date?
Yes, Your Honor. With the understanding from Mr. Graham that if we don't get something with probably in about 15 days, this case will be resolved well before that court date.
Seems like there's probably a good chance of that. I'm
Yes,
not
Your Honor.
sure, I don't have a crystal ball, but I'm just going to put the August 13th date as our next court date, and of course, if, there's an earlier resolution, then I'm sure that will happen. And if
Yes,
you
Your
need to
Honor.
bring it
Mr.
in
Graham,
early, we will do that.
Would love to get it resolved, and we'll do that as soon as we can.
Thank you.
Gerald Greenman is up next.
This is going to be Mr. Gerald Green before the court. I have a plea agreement to be filed. I just need to get Mr. Green to sign it for me.
All right.
Question?
Is there any way I could ask the state something? I mean, I got
Agreement, Your Honor.
Okay.
I need to change one number on here.
All right.
It's all right. I have a history with Mr. Green. I'm more than willing to help him out when I can. Just sign a date that.
Mr. Gates,
What's the date?
do you have a score sheet? Misdemeanor. Misdemeanor?
What's the date?
6/11/25. The reason you offered a misdemeanor is based upon the facts and circumstances of this meeting.
Thank you.
That sounds like something I would say.
May I approach, Your Honor?
Yes. Thank you so much. I cannot make that out. What is
160, Your Honor.
160? Okay,
Yes,
I'm
Your
going to write it right above there, 160. All right. Sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down. If you'll just tell me your name.
Gerald Warren Greenman.
All right. Did you say junior?
Yes, junior, yes.
Okay, just making sure I've got the right person. And attorneys, what is the statute number for the offense that will be pled to?
It'll be misdemeanor battery. I have that as, 78403, subsection 1B.
Thank you.
It's Mr. Medina's homework that got me that, so.
Thank you. All right, sir. Mr. Green, in this case, 25 CF 419, you're charged with one count of felony battery, which is a third-degree felony. Did you have a chance to talk to your lawyer about that charge and any possible defenses you might have?
Yes, ma'am.
All right. Did you discuss the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the last page?
Yes, ma'am, it is.
All right. Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Is anybody forcing you or threatening you to make you enter the plea?
No, ma'am.
Has anyone promised you anything other than what's showing in the agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am. It is dropped to a misdemeanor right now.
Yes,
Thank
I
you.
just have to make sure you discuss the original charge, but it does appear that you're pleading to a lesser included charge of misdemeanor
Yes, ma'am.
battery.
Thank you.
Is that your understanding too, misdemeanor battery?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, ma'am.
All right. Any DNA?
No, no, no.
I do find a sufficient factual basis based on my review of the arrest report. Sir, if you're not a U.S. citizen, do you understand the plea will subject you to deportation?
Yes, ma'am.
Thank you. Looks like you are pleading to that lesser included offense of misdemeanor battery. It's a first-degree misdemeanor. How do you plead to that lesser included charge?
No contest.
I accept your plea. I find it was freely and voluntarily entered. And in accordance with your agreement, you will be adjudicated guilty of that lesser included offense of simple battery, misdemeanor. And you are sentenced to 160 days in the county jail with credit for time served. No probation to follow. It's just once you're done with that incarceration. Is it $622? $622 in court costs, $150 cost of defense. That includes the $50 application fee. And you will have 24 months after you get out of jail to pay those costs and fees before they're sent to collections.
Yes, ma'am.
And did I cover everything?
Yes, ma'am.
Okay. And, sir, you have 30 days to appeal the judgment and sentence of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you, sir.
Okay, thank you.
Thank you.
You have a good one.
Haskins is next.
Your Honor, this is going to be Mr. D'Artagnan Haskins before the court. The state and I talked about an amended offer in this case. If we could we do a July status date?
Monday won't be, or this won't be enough.
No, because I got to go over everything with the sex offender statute.
That sounds fine.
If we could set Mr. Haskins for a status date in July, Your Honor, anticipation is a plea. I want to print out and go over the sex offender statute with Mr. Haskins so that he understands what he's looking at. He's also got a military court-martial case as well that we're trying to attack on us.
All right. So, we have a couple of dates in July. I don't know how full the July 22nd date is, but we also have the afternoon of July 24th. Let me take a look at July 22nd and see.
Just be a plea, right, Mr. Bates, Ms. Lacy, so it shouldn't take long.
How busy is July 22nd? As of right now, I'm sure this will change, the July 22nd date is not looking too packed. So it's really your preference, the 22nd or the 24th, whichever.
I think you'd rather the 22nd, right? July 22nd.
Okay, so July 22nd at 9 o'clock. And that would be a status?
Plea status, Your Honor. Yes, Your Honor.
Plea/status. Okay, and that is in case 20 CF 1593.
Yes, sir.
So I have a note on here, need deposition of investigator
I was
Hill.
going to tack on in the bunch of caution, I'll go ahead and schedule investigator Hill for deposition, just to be safe, in case things go sideways. That way the case is completely ready to go.
That's fine.
Is she back or available? I know that she had been in training for a long period of time and she was expected back sometime.
Ma'am, she's completed for her training, it'll just come out, it'll depend on what her HSI duties are, and we'll have to go through the channels, they'll have to go through channels to set any depositions, because they do have different channels, but she is once again, she's out of training, so it's potentially available.
That is great because I know that her deposition was needed in a lot of cases, so that's good news.
Yes,
All right, great. All right, thank you, sir. I'll see you in July, okay?
Herps is next.
Yeah, this is Mr. Donald Herps, in cases 24 CF 1737 and 25 CF 743. There's been a little bit of change in 25 CF 7.3. The trafficking charge, the controlled substance came back not a controlled substance. State sent off additional testing on some other substances that were in the house. Again, came back not a controlled substance. So at this point, it's my understanding the state is asking to have the firearm that was located in the safe tested for DNA. And that's the game plan at this point.
That is correct, Your Honor. May we approach?
Yes.
Thank you.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
All right, so in light of that, we are going to set both cases. That's 24 CF 1737 and 25 CF 743. Both will be set for August 13th at 9 o'clock. And should the attorneys need to bring it in early, just contact the clerk or my office and we will make it happen.
Yes, Your Honor, and I was telling Mr. Herps, the state's position is, obviously to have it tested. If it can't be tested, then I think we'll get a quick resolution on that.
Yes. So, sir, I have to set the next court date, but the attorneys know that if they can if they have something worked out, they can always contact the clerk's office or my office, and I'll do whatever I need to do to get you in early if there's an earlier resolution. Okay?
How long before you find out if they'll take it? The next couple of weeks. Jake goes next.
All right. That is 24 CF 384.
Yes, Your Honor, this is going Mr. Hill before the court. We have a plea agreement to be filed in his case. I just throw on there that she's been incarcerated since like March 20th last year, just so that she's on the lookout. If I can approach for the plea agreement, Your Honor.
Yes. Thank you.
We were able to successfully get Mr. Hill back from the DOC.
Thank you.
So we can now get this resolved and we can get it off the docket. We do want to make sure that the court has no objection to him going back to DOC pending paperwork in this case because he came over from DOC and we want to get him back.
Absolutely. No problem with that. Let me make sure that nobody else has it. I mean, you mean
Yes, Your Honor. We
You don't
the
want him
jail-
held at the jail waiting on the judgment and sentence?
We don't want that. We want him to go back to DOC as soon as possible.
Okay, is that, I mean, I don't control the transportation, but,
And that's fine. The jail just needs to know that the court has no objection to him going back, and then they know that means they can send him back. He doesn't have to be held.
yes, I absolutely have no objection to him going ahead and being transported back to DOC where he came from without having to wait here and be held up, waiting for me to sign a judgment and sentence. But, you know, I can't order them to do that, but I can say that by all means, I have no objection. And I will sign the judgment and sentence as soon as possible, as soon as I receive it. All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down. If you'll just tell me your name, please.
Tate Hill.
Thank you, Mr. Hill. You're here in case 24 CF 384, and in that case, you're charged with 1 count of grand theft auto, which is a 3rd-degree felony. Have you had a chance to talk to your lawyer about that charge and any possible defenses?
Yes, ma'am.
Did you discuss the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the last page?
Yes, ma'am.
Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Is anybody forcing you or threatening you to make you enter a plea?
No, ma'am.
Has anybody promised you anything other than what's showing in the agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Absolutely.
That's good to hear. Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, ma'am.
I do have a score sheet that shows 44.3 total sentence points for a lowest permissible prison sentence of 12.225 months. Any objections?
No, Your Honor.
Is there any DNA?
No, Your Honor.
I do find a sufficient factual basis based on the arrest report. And sir, if you're not a U.S. citizen, do you understand that the plea could subject you to deportation?
Yes, ma'am.
All right, how do you plead to 1 count of grand theft auto?
No contest.
I accept your plea. I find it was freely and voluntarily entered. In accordance with your agreement, there will be an adjudication of guilt on that charge, and you are sentenced to 12.225 months in state prison with credit for time served. And the state, it says on here, state stipulates that the defendant has already served the DOC sentence, and this sentence is essentially credit for time served. And I do see that the arrest date is February 8th, 2024. So the state is stipulating that the 12.225 months has already been served.
That is correct, Your Honor, the state is stipulating.
Thank you. And is it $515? Okay, $515 in court cost, $150 cost of defense. That includes the $50 application fee. And I am reserving jurisdiction to award restitution to Miss Amanda Lawson Morris. And her address, do I need to state her address on the record, or it's in the plea agreement? How long am I reserving jurisdiction?
90 days, Your Honor.
Okay, I'm going to write that on here.
Yes, Your Honor.
All right. All right, I'm reserving jurisdiction for 90 days to award restitution to Miss Amanda Lawson Morris, address stated in the plea agreement. That is, if there is any. And the defendant will have 24 months after release from prison to Actually, this just says 24 months from today.
Yes, Your Honor.
Okay, 24 months from now to pay the outstanding court costs and restitution if ordered before it all goes to collections. Now, if that goes to collections, it will affect your driver's license. So just be aware of that. And it says in here, this agreement is based upon the defendant being sentenced to DOC in cases arising from this incident in other counties which were resolved last year, and that the defendant has been incarcerated since March 28th, 2024 in Leon County Jail and DOC.
Yes,
Okay. Did I leave out anything?
There you are.
All right, and sir, you have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, I'll appoint one for you. Good luck to you, sir. Thank you.
Yeah.
Timothy Jordan is up next.
Hey, Your Honor, this is going to be Mr. Timothy Jordan. If we could leave him for docket day for plea or continue, we have a plea agreement reached in his case. Unfortunately, I would say it was a Wednesday or Tuesday. Tuesday, Mr. Jordan was arrested on an outstanding warrant for some alleged narcotics found on him at the time they served the original warrant on him. Don't know why there was a delay, don't know why they waited so long, but the state and I have worked out an agreement to try and include that case as well, if we can bring him back on Monday.
That's without objection, ma'am.
Okay, that is 21 CF 2345, 23 CF 1983, and 25 CF 563, and then possibly a new case as well, but we will find out more about that on Monday. I'm setting the cases for docket day, which is June 16th at 9 o'clock. And is that new case assigned to?
My anticipation is it's probably assigned to this courtroom as well, because it's probably.
I know it on the paper that I got, that Lieutenant Oliver gave me at the jail, it's got a date for June 17th.
That's probably me, and that's probably next
Because
Tuesday for arraignment.
I told the judge at first appearance that I had him for an attorney, and so.
Okay,
Yes,
well,
Your Honor.
whatever that case is, we might just go ahead and set it on Monday.
I don't think the clerk has opened the file yet.
Oh, okay, well,
The state and I have been checking pretty regularly to make sure, because we want to get it snatched up as soon as we can.
No, it's 893.1368. I know that's the statute.
Possession of controlled substance.
Yeah. And it ain't a controlled substance.
Don't worry. We'll figure it out. All right.
I just ain't gonna wait on the lab.
yeah, I don't see it on the June 17th docket right now.
No, Your Honor, my thinking is it's probably, I think July 17th is an arraignment date. That's probably when it's set.
It might have been 7/17 then.
July 17th, sorry,
Yeah, it was July, my bad.
no problem. So,
July 17th.
okay, well, whatever the case may be, we will sort things out on Monday, June 16th. That's this coming Monday at 9 o'clock for docket day in the 3 cases that were on the docket for today, and then possibly the new one.
Yes, Your Honor.
Okay? Thank you, sir. I'll see you Monday.
I'll come see
Michelle,
you.
thank you, Judge. Next.
Okay.
Go to my last one that I've got that's not going to be waived is Michelle Blinka. She's before the court in 20, I'm trying to get it right.
25.
25 CF 455. At this time, we'd like to leave her set for a plea continue on docket day. I'm going to try to get an answer from the inpatient treatment program that she's been screened for. And if we can get an approval, then my anticipation is we'll have a resolution on Monday.
All right, so we will schedule the case for June 16th, Monday, docket day for plea or continue.
Yes, Your Honor, and I wanted to address another case. It's 25 CF 855. That is actually scheduled for an arraignment tomorrow afternoon with Mr. Strauss. We're going to go ahead and enter a not guilty plea on that one. And then if we could have both cases scheduled for docket day for resolution.
Okay, so arraignment is tomorrow, but you're entering the not guilty plea now.
Yes, Your Honor.
Okay, that'll take it off tomorrow's docket.
save her transport.
Yes, hopefully. So how do we let the jail know that?
I can tell you.
Okay, she does not need to come tomorrow, but she does need to come Monday.
Yes, sir. I think I've emailed Deputy Rominger already, but I'll email her again to let her know not to bring this in.
Okay, and so we will add 25 CF 855 to Monday's docket.
Yes, sir.
Great. All right, ma'am, I'll see you Monday. Thank you.
Alright, Mr. Medina, we're gonna start with you.
Your Honor, Steve Medina with Kia L. Alloway, 25 CF 784. Your Honor, since he was last before the court, we took depositions. The state and I and my investigator are working on some additional discovery. So there are some moving parts, but I anticipate filing motions to suppress and dismiss during this cycle. I'm working on those. And I would ask for a full cycle continuance.
All right.
And that's without objection, Your Honor.
All right, thank you. So 25 CF 784 will be continued and reset for pretrial on August 13th at 9 o'clock. And I expect there's a VOP coming 24 CF 1744. I'm not sure when that's set.
Yeah, and I think that just needs to ride along with it, Your Honor, at this time. I think the new law is the sole basis for that. So we need to get the motions filed. They will, at least in part, be relevant to the VOP issues, if not wholly. I think they'll both be relevant to the VOP.
So back on May 22nd, both of these cases were set to be tracking and set for today. There was an order that came through in the VOP case that had been set for July 10th.
Let me take a look.
Okay, so we can have that be on for July 10th, but honestly, I don't see any benefit to that. We may be having a July court date on a motion or one or more motions if we get it filed in time. But I don't think we need to be on a miscellaneous calendar, but.
July 10th, I think that's a, is that the order entered on May 22nd?
Yes.
Okay, I don't see a date in there, and I should have caught that, but, and I don't see a date in the motion either. We don't know why it's on July 10th? Because that shouldn't be on that day.
I would customarily request that they ride together.
Yes. Yes, so it shouldn't be on July 10th no matter what. So I'm not sure why that is. I don't either. But what we will do is, why don't we set both cases, that's 24 CF 1744 and 25 CF 784, both of them, let's set for August 13th.
Thank you, Your Honor.
Sure, at 9 o'clock.
And he may end up coming back before then, hopefully. If we
Oh,
get
absolutely.
something filed. Thank you.
Absolutely.
Appreciate it.
Thank you.
Your Honor, Rashad Armstrong is approaching in 25 CF 323. He also has a VOP that the state is going to request to continue that was set for tomorrow. These need to ride together. We have a June 17 motion to compel hearing. He probably just needs to be continued to June 17 rather than coming on docket day. But we do need to bring him back next week. So I get my dates confused. So would that be Tuesday instead of Monday? Okay.
And Your Honor, the state is not going forward on the VOP hearing tomorrow. It is not the state's continuance, though. It's due in part because a motion to compel was filed the same day I filed my notice of hearing for the VOP for additional body cam video, specifically the special response team video that I got a hold of records today at the sheriff's office. They are in the process of getting those videos to me in partially redacted way. I'm ready to move forward on the VOP hearing with or without that body cam. So I'm not moving for continuance of the VOP, however, I'm not gonna necessarily object to defense's request to go forward because they do want this body cam that I'm working on.
Yes, Judge, I mean, it's all part and parcel of the same situation. It's, I think, the sole basis for the violation alleged. And I do ask that everything be continued to June 17, including the VOP. We'll come in then, we'll see what we have by then, and go from there, Your Honor.
Okay, just one second.
And everybody's been, both sides have been working the case and everything. So I think it's
Yeah,
probably the
just-
first time out or second time out.
I just looked at the VOP affidavit in 22 CF 2107, 22 CF 2138, and 23 CF 1291, and it does appear to be the new charges are the basis for the VOP. And so what we will do is, Mr. Medina, are you requesting that the VOP hearing not go forward? I think
Yes, Your Honor, I appreciate the state's clarity. I certainly do not mind it being the defense request.
Okay.
Because I think the motion to compel related evidence is germane to both cases.
Okay, so the hearing that's scheduled for tomorrow, June 12th, on the 3 VOP cases I just read out, the 2022 2 cases and 1 2023 case, that is canceled and it will be reset. Contact either the clerk's office or my office and we'll get it reset. The case is scheduled for June 17th for a motion to compel, and that is in the new case, 25 CF 323. And so what we will do, instead of bringing the case back on Monday for docket day, we'll just set everything for June 17th if it isn't already. So all 4 cases.
Yes.
And I just want to let all parties aware, I am working on those videos, Records is working on it at the Sheriff's Office. It is a lot of videos to go through and redact. I'm hoping to have it by the 17th, but it's not a guarantee.
I apologize, I just was not familiar with the need for redaction. It's usually just law enforcement video, but there may be something special that I
Because
don't
a
know
special
about.
response team had showed up, so their tactics and stuff are protected. So it's not going to be the full videos of the special response team.
And also so that the court understands, I understand if we don't work things out, that the state would intend to go forward with the VOP evidentiary. It'll probably just be sometime a little bit later than now, once we hash out these remaining issues. Now, it's also possible to resolve the case. The motion to compel may need a little bit more of a continuance. Let's see where we stand on Tuesday, Judge. I'll be mindful that the state's producing and try to review what we've got.
So do you want me to put August 13th down as the next pretrial date? Then I know we're still coming on the 17th, which is next week, but unless y'all are...
I think that's probably prudent that we go ahead and put that down. We can always schedule something earlier. What I don't want to have happen is the state not have a clear opportunity to tell the defendant when it's his last chance to take the state's offer. I know that I don't expect we're going to have any problem through June 17th, but going forward beyond that, I want to make sure he knows what his choice dates are, events and stuff, milestones. Now, depending on what happens at the motion to compel hearing, I'm not making any commitments, or he's certainly not. But.
Okay. So we're going to set all 4 cases for June 17th. I think one's already set. That's the motion to compel hearing. And then we're also going to go ahead and put everything down for pretrial on August 13th, just so we have that next pretrial date, which I'm required to set.
Thank you, Your Honor.
Sure. I do have a question on April 21st. The FDLE results were still outstanding on the new case. Have those come in?
Your Honor, we do have FDLE. that was produced. The report was dated May 19, 2025, and the state did produce it in the state's third amended discovery exhibit dated May 20.
Great, just following up on that, that's good news, that at least that's come back, that won't hold up anything anymore. So,
And I would just request, I know I'm working on the body cam video, but if there is anything else outstanding that defense is wanting to, please let me know, because I am eager to set this VOP hearing.
Yeah, I understand, and I try to be very methodical, and I certainly haven't intentionally left anything out. If I needed anything else that I knew of, I'd be trying to compel it. So right now, there's nothing else.
all right. So, sir, I'll see you on June 17th. That's next Tuesday, okay?
Thank you.
Lucius Baker's up next.
All right.
Your Honor, Steve Medina, Mr. Lucius Baker before the court. I was advised through my investigator that was meeting with him that Mr. Baker said he had hired a private lawyer. I did check as of yesterday. The private lawyer that he named had not entered an appearance. However, because it's complicated, it involves minors, I'm not going to just willy-nilly, when somebody tells my investigator they've hired a private lawyer, I'm going to start scheduling depositions. So the court may wish to give him some time to get an appearance entered.
Okay. Sir, did you want to say something?
Yes, ma'am. I was under the impression I was going to be here for a bond hearing, and also I did hire Ricky Darum. He just, this was filed before we made payment to him or whatever, and I was going to go with it and try to see if we could get the bond reduced, and I get out and figure out everything else. But we did retain him. He just we went with this first because it was already on file.
Okay, wait just a second. Let me make sure I understand.
I filed, Your Honor, a motion to compel, defendant's motion to compel and for bond reduction.
I see that.
It was filed in good faith by defense counsel on May 29, 2020. It was misstated 2022, meant 2025.
Yes, yeah, I see it. I see it.
But in any event, we did not notice it for hearing because before we could notice it for hearing, he informed my investigator who informed me that he has hired Ricky Dyram. So I've been waiting for that to be Mr. Dyram's motion if he chooses to adopt it. I'm certainly not here. We have not noticed that motion for hearing, nor do I intend to if he's hiring private counsel as he stated.
Okay. So you've hired Mr. Dyram. Is that a yes?
Yes, ma'am.
Okay. So he hasn't filed a notice of appearance in your case yet. Do you know when that might happen?
Well, according to him, I talked to him this morning before I came into court. I mean, I called and talked to him personally. He said he's got the money, and then he said he noticed that the motion for a bond hearing was today. So he said, go ahead and go with that, and if you can get the bond reduced, we get you out, and we can go forward with the rest of the case, and I can file a notice to appear for appearance and take over from there.
That motion's not scheduled for today. Today is just pretrial conference. Okay? Today is just quick, like, are you ready for trial? Are you going to enter a plea? Are you asking for a continuance? That's about all of the options on a pretrial conference day. That's what today is. So today, I don't hear motions on pretrial conference day. So there is no way in the world I would be hearing a bond motion on this type of court date.
Okay. Well, there's a misunderstanding then on my part.
Yeah, so,
Your Honor, we think it needs to be continued August 13, and Mr. Dyram can certainly set any motion that he feels is appropriate when he enters his appearance.
Okay.
August 13 pretrial is what I think makes the most sense.
Okay, so, sir, Mr. Dyram is going to come in and represent you then?
Yes.
Okay, so are you requesting a continuance of your case?
I'm going to have to. I don't have him here right now, presently.
Okay. Yeah, the other option is to go to trial, and
We're not ready to do that because I haven't taken the deposition.
Okay. All right. So continued at defense's request to August 13th at 9 o'clock for pretrial conference. And then, of course, once Mr. Dyram comes into the case, he has to file something, and then at
Okay.
that point, I'd sign an order
Yes, ma'am.
relieving Mr. Medina of counsel, and Mr. Dyram would proceed on and represent you. And if he wants to file a motion, set a hearing, or if he wants to adopt Mr. Medina's motion that he filed, Mr. Dyram can do that too. That's up to
Okay.
Mr. Dyram and you.
Yes, ma'am.
But Mr. Dyram knows how to set a hearing if he needs to in this case, okay?
Yes, ma'am.
All right.
Thank you.
Thank you. August 13th at 9.
Paul Bessinger is next.
Under Seven Medina with Paul Bessinger, 24 CF 2533. He's approaching, Your Honor. I'm asking to have him return on docket day for plea or trial.
Okay.
I do wish to advise the court that the state and I have discussed the victim to the alleged incident, the witness, not the alleged victim. The alleged witness, who is apparently in treatment, and the state had been intending to make him available by Zoom for a deposition. The state did not have success in setting that up. I don't know if it's because of his treatment or whatever, but I think we have an understanding of a way to resolve that. A workaround is the state deems that he wouldn't be available this cycle for trials, won't be calling him, so we won't need to take his deposition as long as the state's not intending to call the witness.
Okay, let's see what the state's position is. I will note that on April 21st, I did say that that was the last continuance.
Right, and we're ready
Yeah.
to go.
Okay, so state, where do we stand?
Your Honor, the state wouldn't stipulate that it wouldn't necessarily call that witness at this time. I'm still in the process of reaching out to the treatment center at this point. It's hard to get a hold of people there and to get a call back. I've done my best to try to get them to help me coordinate a Zoom deposition for this. If it gets to a point where all of my efforts are to no avail, then I think that would be a slightly different discussion. We do have a few more weeks out till trial, so I don't want to stipulate to that at this point. I will make myself available, and hopefully defense would too, if I can get something, a quick 30-minute deposition scheduled possibly via Zoom before trial. But other than that, the state is ready to go.
So, Your Honor, I think based on prior practice with the state attorney's office, I don't think that we won't be able to cooperate and work that out. If they can get the person to come to trial, I'm sure they can get the person to do a Zoom deposition, and she's stating they will make every effort to do that. So right now, we'll just kind of keep our powder dry on that issue, and just have him come back for docket day, Your Honor, for plea or trial.
Okay.
And I do note that I do want it to be real clear on the record. The state has made an offer. The state has represented that it expects the alleged victim to show for trial. The state has indicated that the defendant's position on a resolution was not acceptable and that its offer was 24 months DOC. And we need to know from the court and or from the state what's the last day for him to take the state's offer. If he's coming back on docket day, I know that's customarily what this court advises, but I just don't want that to not be discussed today so he can be mindful of it. If he's going to roll the dice on trial, I don't mean disrespect, I'm going to be represented the best I can, but if it's based on the notion that somebody's not going to show, that's a gamble that I'm not recommending he take.
Okay, so typically I would, the last day I would accept a negotiated plea would be on docket day, absent some, sometimes there are extraordinary circumstances that the situation changes that would motivate me to take a negotiated plea at a later time. Generally speaking, it's docket day. What I do that day is I have the state put their offer on the record. I would question the defendant to make sure they understood the offer or had questions about it, and read out the charges and list out what the exposure is, and then, you know, just to make sure that everybody is informed and making intelligent, informed choices.
The state's intent is to revoke all offers on Monday after docket day.
Okay.
Unless, of course, there's something extremely mitigating for me to accept that as well, Your Honor, at that point, but that is the state's intention.
And that's what I told him, I need the situation, so now he knows.
Yeah, I mean, there have been circumstances where we've extended the deadline, but there have been specific compelling reasons. So.
Very good, Your Honor.
Yeah.
We'll see the court on Monday then, if that's okay.
Okay, and just so the parties can plan ahead, the second trial week is looking packed. So let's aim for the first one, which would be the week of June 23rd. So let's aim to that week, because I'm worried about everything getting jammed up on the second trial week.
So that, being mindful of that, it's going to be very important for the state to let us know if we're going to need to squeeze in a deposition because of the availability of the person, the witness.
Right.
You know, I'll do everything, and I can cooperate. I know Ms. Gainer will too, so I'm not worried about our lack of cooperation. I'm just saying, we don't have weeks to go.
Right.
Sounds like we've got like a week and a day or something.
Right. So, and we'll discuss that further on Monday during either docket day, or if we get to jury review, which is next Thursday. Of course, we'll have some concrete scheduling plans then. So, sure, June 16th, 9 o'clock.
Your Honor, may I have just a second?
Of course.
He's whispering. Robert Bolton. Thanks.
All right, after this next case, we will take about a 10-minute break.
Thank you, Your Honor.
Sure, just let you know.
Robert L. Bolton is before the court in 25 CF 595. I get confused on what's on the docket today or tomorrow, but we have this new law case, 25 CF 595, and we also have a VOP case that he has, 23 CF 2153. I'm not sure if it's riding along today.
It is.
We have a violation of probation agreement. I had attempted to do it in absentia, but we couldn't get all the signatures together in time. May I approach with a VOP agreement in 23 CF 2153, Your Honor?
Yes.
And it is a misdemeanor resolution, so there is no score sheet.
Okay.
Thank you.
Thank you. Thank you so much.
And it was with JCS, so it's not going to involve state probation, writing the stuff down.
Okay.
Your Honor, should I announce?
I'll do it.
Okay, thank you.
And you can correct me if I
Yes,
get it
yes,
wrong.
thank you.
Sure. Sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
Yes, ma'am.
Thank you. Thank you. You can put your hand down. If you'll just tell me your name, please.
Robert Lee Bolton.
Thank you. In case 23 CF 2153, it's alleged that you violated your probation. Have you had a chance to talk to your lawyer about the allegations that you violated your probation and any possible defenses you might have?
Yes, ma'am.
Your Honor, could I?
Yes.
I apologize.
No problem.
I want to make sure that I haven't made a mistake.
Okay.
Because there were technical grounds for the violation. And I want to make sure that he's admitting only on technical grounds. I don't want, and it does state, admits the violation of technical grounds only, but I just wanted to make sure that was super clear on the record. I did not make a mistake, but I'm just.
Right, we will specify, so
Okay.
let me find that in here.
Because he's not admitting the new law.
Understood, we will clarify.
Sorry, Judge, it
No,
just
that's-
been a while since I looked at it, and I just had a, oh boy, I don't want to mess that up.
Let me find the affidavit.
It's a JCS one, so it's a shorthand. Should I approach with it? I got
Got it right here.
Okay.
Okay, so let me clarify what the allegations are, okay? I am looking at, it's actually in the warrant. They attached their affidavit as part of the warrant that I ended up signing. So it's docket number 91, and it was entered on March 27th, 2025. And the allegations of violation of probation, first of all, there's the new law offense, which is the subject matter of case 25 CF 595. Then there are the following allegations: that Mr. Bolton failed to complete his 50 hours of community service work, that he failed to complete the advanced driver improvement course, that he failed to pay cost of supervision totaling $110, and failed to pay fines and court costs totaling $368, but it says the outstanding balance is $38 on that. So those are the 4 allegations that are not part of the new law case. So, sir, have you had a chance to discuss all of the allegations that you violated your probation with your lawyer?
Yes, ma'am.
Okay, and it's my understanding that this agreement is an admission only to the community service work, the driver improvement course, cost of supervision, and the balance of fines and court costs?
Right, Your Honor. He's just pointing out, which is true, that he and his family have made efforts to pay off fines and court costs, and it looks like it was substantially completed. So it's a partial admission on that, as the court has stated, as to the outstanding balance.
I'm writing on the plea agreement that it's not an admission as to the VOP allegation of the new law case, okay?
That's correct, Judge. Thank you.
Sure. In fact, do you want to look at this and make sure that this is?
Thank you, Your Honor.
Sure. Make sure that that
Yes,
covers it.
Thank you. Sounds perfect. Thank you, Your Honor.
Sure. Thank you.
Thank you.
All right, sir, so you said you'd had a chance to talk to your lawyer about all of the allegations you violated your probation, and is it your understanding that this agreement and your admission is only going to apply to the technical grounds that I read out a minute ago about community service, driver improvement course, and cost of supervision and the balance of your court costs?
Yes, ma'am.
All right. Is anyone forcing you or threatening you to enter the admission today?
No, ma'am.
Has anybody promised you anything other than what's showing in the agreement?
No, ma'am.
Do you understand the rights that you give up when you admit to violating your probation?
Yes, ma'am.
You understand you have the right to have a contested hearing and make the state prove the allegations?
Yes, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, ma'am.
Do you understand if you're not a U.S. citizen, the plea could subject you to deportation?
Yes, ma'am.
Are you admitting the 4 technical grounds of violating your probation that I listed a couple times now? Everything but the new law
Yes, ma'am.
allegations? All right, I accept your admission. I find it was freely and voluntarily given. In accordance with your agreement, I do find that you have violated your probation as to the following allegations. That's the failure to complete the community service work, failure to complete the advanced driver improvement school, failure to pay cost of supervision totaling $110, and failing to pay the balance of your fines and court costs. As of the time that this affidavit was entered, it was $38 was the balance. I'll defer to the clerk as to whatever the actual balance is, if that's accurate or not.
And there are going to be some additional costs for today, Your Honor. as
Yes,
well.
yes.
Currently, I show zero balance.
Oh, looks like that one's,
Okay.
There was a payment on May 2nd of 25.
okay, so the, what do you want me to do with that?
Could the state stipulate that he need not admit to the fines and court costs admission?
Based on representation, Madam Clerk, the state will stipulate that.
Then I will specify on here further, it says not the VOP allegation of new law case, and I got the case number, or unpaid fines, or, let's see.
Fines and court costs.
Fines and court costs.
Thank you.
Unpaid.
Thank you, ma'am.
Fines, court costs.
Great, thank you, Madam Clerk.
I wrote that on here, or unpaid fines.
Thank you, Your Honor.
Sure. All right, sir, so there's been a previous adjudication of guilt on the 3 underlying misdemeanors, so that, of course, will remain. Probation is revoked and terminated, and you are sentenced to 90 days in the county jail. That would be concurrent on all counts with credit for time served. There will be a... Okay.
Because they were misdemeanor resolutions, my understanding is the VOP fee is only $50. The cost of well, it's still $100. I don't know why it was broken up that way. That's just the way JCS does their breakout. It's still $100.
Let me check with
It's still going to be the $100 because it's under a CF case. Same with $50.
Okay.
Okay, so it's actually $100.
But that's a combined
Right.
VOP and cost of prosecution. Do you just typically combine it into 100, or is it one or the other?
It's
For the $100 prosecution fee?
Yeah, yes. Well, when we say, I typically would write $100 VOP fee.
It's only one thing, and it's just the prosecution fee.
Okay. So it really should be 100 COP then.
correct, and I got rid of the
Would the
$50.
courts make that change?
Yes, I X'd out the $50 VOP that's right before where it says the COP fee. I'll show it to you. But I put $100 cost of prosecution fee, $150 PD fees. That includes the application fee. Is that right?
Yes, Your Honor. He understands.
The total is $250.
Including the PD fees.
That includes the PD fees and the application fee. And it says here D6 outstanding traffic requirements. That means your license will be suspended until you satisfy that driver improvement school. Is that accurate, Mr. Medina, just that one?
Yes, and I'm just not sure if there were any other, whatever the traffic-related requirements are, they are D6. You've got to clear them up. I'm just not certain it's only advanced driver improvement course. That's probably it.
Okay, state is the 50 hours of community service. Is that to be D6'd as well?
I don't think that has to be D6. That just basically goes away. When I used to do a lot of county court, we would say waive non-monetary requirements, but we don't typically say those extra words in criminal felony court.
Okay. So
it's understood there's going to be a waiver of non-monetary requirements except as to traffic requirements, which are D6.
Which would be the driver improvement course.
And because it does specifically say that the outstanding monetary obligations will go to collections after 6 months.
Yes.
They don't.
Right. So outstanding monetary obligations to collections after 6 months. So sir, after 6 months from today, anything you haven't paid on this case is going to go to collections, and that will affect your driver's license as well. So You have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, I will appoint one for you. Good luck to you, sir.
Your Honor, there was one other matter, just so everybody's clear on the court docket for tomorrow. It does come to mind. We have resolved the June 12th bond hearing issues because the court entered a stipulated order reducing bond in the new law case, 25 CF 595. So that moves the need for a bond hearing tomorrow. So he does not need to come back tomorrow. And I would ask to have him put on, assuming he can make his bond, it's a big bond, there's GPS and so forth and so on. He could probably be on August 11 for a new court date on the new law, Your Honor.
Okay, so August 11th at 9 o'clock is pretrial conference, and that's in case 25 CF 595. Sir, if you happen to still be incarcerated on that day, then we're going to move you to August 13th. But if you're out, you need to be here on August 11th at 9, okay?
Yes, ma'am.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you.
So, Madam Clerk, we're all for tomorrow. I don't know, Judge, if I'll have time to do an order of cancellation, but we're
I don't even know if it's on the docket for tomorrow, actually. Oh, okay. All right. Well, we're going to take a 10-minute break since we've been in here for more than 2 hours. So we'll be back in just a few minutes, and we will carry on.
All right, please. Let's bring it back on Monday.
Yeah.
Yeah. Let's move that to Monday so we can. Well, I told them we might be able to, so yeah, perfect. Yeah, bring it back to Monday.
Sounds good,
Yeah.
thanks. Rachel, he's just gonna bring it back Monday. But he's just gonna bring it.
It'll be a continued Monday.